Good morning, and thank you for joining me on the Path to Liberty. It's Monday, February 28th, 2022, and on this episode, I'm talking about NoKnock warrants. I've got a brief overview of what these things are, and then a quick comparison to what they should be using instead. And then I've got highlights of a number of Supreme Court opinions. When I think of Supreme Court cases, I generally think boring, but I'm going to do my best to make sure that this is at least interesting and informational at the same time. But I've got an overview of some court cases going back to the 60s all the way through 2006, how they made this up out of thin air, applied it to the states, and then expanded on it over and over and over. So it's become the norm. It's become a routine tool instead of what they said. It was just going to be kind of an emergency thing, something we face all the time. But first of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage is everything you need to follow us. It's got all the archives for almost 4 years. On individual episodes, I publish a blog post for every single individual episode, and I've got a bunch of different ones categorized on that same page as well. On each episode, you can find all the platforms that we either live streamed on the video, or we archive the video, or we have the archive audio-only podcast edition. You can find stuff that I mentioned in the episode today. I've got a bunch of articles, a couple of PDF papers, some other episodes to reference as well. That way you can understand and learn more in context on your own time. And you can even find our membership program where you can put your financial faith behind our work for as little as $2 a month. And I don't think anyone makes this every single penny go a long, long way in support of the Constitution and liberty like we do at the TAC. I'd be very grateful for any consideration you can give to joining us today. The show homepage, 10thamendmentcenter.com/path to liberty. It's all spelled out, 10thamendmentcenter.com/path to liberty. And while we allow people another minute or so to join us, get notifications to join us on the live stream, I want to say a quick hello to everyone out in the live chat. I should also mention I did over the weekend a little tinkering with my lighting. I've noticed it was a bit off. So I did some updates. I moved my overhead light a little bit back, changed the soft key light a little bit, but hopefully it looks okay. If you've got problems with the video quality, please do let me know. Anyways, hi to Cheriton Farmer in Missouri, Clay Kent, good to see you, buddy. Justin Morrison, Tim Martin in Arizona, DHD Van Horn, it's been a while since we've seen you. Joyce Code in Arkansas, Mind Your Liberty in Missouri, Rhoda Juarez, Damian Bernard Buckley, Leslie G., and also in Missouri representing. Appreciate the comment, Leslie, on the intro. It's been a while since I've used that one. Gunay, also in Missouri. Haji in Oakland County, Michigan. Thomas Staples in Central New York. Lawrence Smith. Senator D.T. Lawrence Smith says, timely topic. I'm investigating a few of these in HTGN. Anyways, keep us informed on your research and what your progress are, Lawrence. You can also email me, team@10thamendmentcenter.com. Anyways, let's get right to this. I want to start out with a quick overview of what a no-knock warrant is. Here from, and it was interesting to see, this is generally the opposition to no-knock warrants in recent years have primarily come from the left. But I think once we have things like Gun Owners of America finally coming out and posting a tweet just in the last couple of weeks, hey, we've got to recognize this is a dangerous scenario, giving police the power to actually just enter without notice. It creates a dangerous situation for gun owners, and I'm glad to see that they're coming out publicly opposing these things as well. But what are they? Here, first of all, from Brian Dolan. This is a paper in St. John's Law Review. It's very interesting stuff. I encourage you to read it if you want to. It's 32 pages, but I will link to it in the show notes, of course. He says, a no-knock search warrant authorizes the executing officer's entrance of premises to be searched without giving notice of his authority and purpose, usually upon reasonable suspicion. Notice it's no longer probable cause based on oath or affirmation, particularly describing the person, place, or thing to be searched or seized. It is now reasonable suspicion, a lower standard. That knocking and announcing would be dangerous or would result in the destruction of evidence. And if you think about destruction of evidence, we know that the primary motivation behind pushing these forward around the country, they didn't exist much when they first started, pushing them forward was really about the war on drugs. But I'll get to that in just a moment. First of all, here, let's get a comparison. Of all places, Teen Vogue has a very good overview of this in an article. But they're mostly citing a professor on criminal and juvenile defense clinic, an associate professor, Rachel Moran. She says a regular search warrant requires the police to do three things. They have to go between 7 a.m. and 8 p.m. when people are more likely to be awake and not startled. 2, they have to knock on the door. And 3, they have to announce their presence and wait. That it's not just knock and blast in. Knock, knock, hi, we're here. No, the general standard is about 30 seconds. Some places want to do it for like 10 or 15, and that basically creates a scenario where they use that all the time, and it becomes a very dangerous situation as well. She adds, quote, a no-knock warrant removes all of those things, or it can. So they go outside those times between 7 a.m., 8 p.m. Some states are different. They have to knock on the door, and then they have to announce their presence and wait. They also have to clearly identify where they're from and why they're there. Here back to Brian again from St. John's Law Review. These no-knock warrants authorize law enforcement to dispense with the common law knock and announce requirement. There's hundreds and hundreds of years of common law precedent where this comes from, and the founding generation followed those principles, put those in their constitutions, and now we basically don't have it anymore. We only have it when government thinks it's okay for them to use the standard that we're supposed to have all the time. Historically, he writes, the knock and announce requirement was viewed as an indispensable protection for both citizens and police, for homeowners against unreasonable searches and seizures, and for law enforcement officers against fearful homeowners who might mistake them for burglars or prowlers. Think of someone who might have a firearm. Some people who believe in the right of self-defense, who actually want to exercise that right. Someone comes blasting in, they pick the wrong place, and this happens quite a bit when we're talking tens of thousands of these things happening per year. You barge in on somebody, that creates a firefight. Someone's going to get shot or killed. It's a very, very bad scenario. Now, I've covered in much more detail basically the background about knock and announce, about how no-knock warrants came to be, and the fact that they're generally, supporters of the monster state are generally lying about these things. They claim that they're only going to be used for extremely dangerous emergency situations, and if any time you hear it's for an emergency or for these people only, we should all be just laughing at the absurdity of that recognizing the danger of allowing them that, because even if they only use it that way at first, eventually some politician is going to come along and wield their power in a way where they're going to expand this and eventually use it on everybody. We've seen this happen with the income tax. We've seen it happen with the Patriot Act. We've seen it happen the last couple of years with an emergency power to lock things down, which none of these emergency powers exist. I can read as many constitutions as I like around the country, and whether it's in the states or on the federal level, and you're not finding, the right to keep and bear arms shall not be infringed unless government thinks there's an emergency and they have to. That kind of stuff doesn't exist. But they're using them so often, they've basically become routine. These 2 episodes. First of all, nullify the police state NoKnock warrant edition. This will be linked to in the show notes at 10thamendmentcenter.com/path2liberty, and then their lying NoKnock warrant edition. Both of them will be linked there. Now, we know that these actually started really in the 1960s as far as Supreme Court opinions. And that's how Tom Nolan put it in a nice article over at The Conversation, which I found through the Marshall Project. Supreme Court rulings going back to the early 1960s have affirmed this ability to enter a home unannounced under certain circumstances. But it only really began to be used regularly under the so-called war on drugs. So you give them unconstitutional power because you're afraid of how things are. Again, fear is the foundation of all governments. Always has been. All their power is based on fear of something bad happening. And a lot of people are fearful of drugs. So they're okay with building a police state to try to shut it down. And all that does is build a nasty police state and rips everybody off because it hasn't done anything to win the war on drugs. Side note. So that's where it started, but it really goes back to a federal knock and announce statute. So the common law practice had been there since the 1600s or so, and then they put it into statute. And as soon as they start putting things into statute, somebody's going to manipulate it. The federal knock and announce statute, it's found in 18 U.S.C. 3109. This was enacted under emergency conditions to prosecute espionage rings and arms smugglers during World War I. Since its enactment in 1917, it has governed the manner in which federal officers execute both search and arrest warrants. So they're basically saying, okay, you got to have this knock and announce standard. This is from Akron Law Review. I will link to that in the show notes as well. And then in the 1960s, they took this knock and announce statute and said, well, there's some exceptions for federal agents because the federal courts were looking at this primarily under federal purview as restricting federal agents. And this is the 1963 case of Wangsung versus United States. Here, the court recognized 2 more possible exceptions to the federal knock and announce statute. One, the peril exception. So someone's fearful of some kind of imminent danger. So you gotta actually get in there. And 2, the destruction of evidence exception. And destruction of evidence, primarily flushing drugs down the toilet. That's the number one reason. So that's 1963, I believe. Another one in 1963 is this case, Kerr versus California. It was a case before the United States Supreme Court. This is from Wikipedia, which incorporated the Fourth Amendment's protections against illegal search and seizure. So this is taking the restrictions of the Bill of Rights, which were originally meant to be applied to only the federal government. That's how the founders and the ratifiers understood it. And after the 14th Amendment, they the Supreme Court took the 14th Amendment in the 1920s and started applying it to the states. And a lot of people think this is a very good thing because then you create a standard. So a lot of people would cheer Kerr versus California of saying, well, now the states have to actually follow the restrictions in the Fourth Amendment. We don't have to worry about the state constitutions because now the federal constitution applies on the state level. And here, again, the Fourth Amendment's prohibition on unreasonable search and seizure and the exclusionary rule for evidence obtained from unreasonable search. So that is, if they actually obtain evidence that was not following the Fourth Amendment's restrictions or prohibition on unreasonable search and seizure, if they obtained evidence, then they try to present it in court. You could move to say, well, they violated the Fourth Amendment. They violated this standard of reasonable search and seizure. That's the only time they can get this evidence. So you've tried to introduce something, we're going to make a motion and I'm going to get that evidence disqualified. And they made that apply to the states through the 14th Amendment. So I know a lot of people who love liberty would be like, okay, great, the states are terrible. They need to be held to a standard. The federal government is going to come in and protect us from the states. And that was a state drug war case. And in fact, in that scenario, it was California restrictions, prohibition of all places, on cannabis, where there was a warrantless search, a warrantless seizure, a warrantless arrest. It was upheld by the state courts, so people appealed it to the federal court, and then, well, the state won in that one. And that's where we get, okay, this is kind of starting. They're taking this standard and applying it to the states. But they also found, for the first time in Kerr versus California, exigent circumstances which excuse compliance with the knock and announce principle. So they're saying, on the one hand, it sounds like a good thing. Okay, we're going to require all the states to follow the Fourth Amendment. But according to the Supreme Court, the Fourth Amendment doesn't mean what the Fourth Amendment means. The Fourth Amendment means, well, there's some exigent circumstances. There's an emergency clause, an emergency out clause for the government where they don't actually have to follow this principle. And now, because it's incorporated against the states, it's not just California who's violating people's natural rights. It's not just California, but it's a standard that can be used for the entire country. Here from Amanda Bowers in an article about a bill that we're following in Iowa. She mentions that the next case that we're talking about happens in 1995. That's the case of Wilson versus Arkansas. Here, the Supreme Court established that police must peacefully knock, announce their presence, and allow time for the occupants to open the door before entering a home to serve a warrant. So that sounds good. Okay, well, we're applying the Fourth Amendment to the states through incorporation through the 14th Amendment. And now, well, there's exigent circumstances that they created in 1963. Then in 1995, they're saying, well, they got to knock and announce. But the court again allowed for exigent circumstances applied to the states if police fear violence, if the suspect is a flight risk, or if officers fear the suspect will destroy evidence. This is primarily, again, for drug war cases. It's almost always used for drug war cases. The unconstitutional federal drug war, we can talk about the states in different episodes, but that's primarily what it's used for. And then they took a high standard, they applied what we thought was going to be a high standard, and then they watered it down. Here again to Brian Dolan in St. John's Law Review. So 1995, then 1997, 2 years later, in the case Richards versus Wisconsin. Here the court explicitly approved of states giving magistrates the authority to issue no-knock warrants. So that now they had this standard. Then they said in this Richards versus Wisconsin, now any magistrate can issue a no-knock warrant. Before long, he writes, courts nationwide began relying on Richards in upholding searches conducted pursuant to no-knock warrants. So here's an example of how incorporating one of the Bill of Rights on the states has resulted not in an improvement in liberty, but in relying on the Supreme Court to protect liberty. And the Supreme Court absolutely sucks. But they're terrible. And so as soon as they do what we think might be a good thing, then they water it down and it gets watered down for everyone. So courts around the country, because of the Supreme Court watering down the Fourth Amendment, applying it to the states, now use that standard in applying their actions to no-knock warrants. And despite Brian wrote, and despite the court's rejection of a blanket exception to the knock and announce requirement for felony drug investigations, no-knock warrants are, to this day, primarily used in drug investigations. And I think that's why so many people on the conservative end of the spectrum have been okay with it. They're going after bad guys. But if you think that they can have power to do stuff that they shouldn't have because you don't like the people that they're going after, or you want the people they're going after to be caught and prosecuted, doesn't matter what the issue is, sooner or later someone is going to use that power against you when they say maybe your .38 is illegal or your pistol brace is illegal. Maybe they'll start using that standard on you for those things. And we need to oppose the first approaches of tyranny. We don't wait until it hits us, but it's just a warning there. Now back to Amanda Bauer. She notes that the next case, so we've got 1963, two cases, When was the next one? It was 1995, then 1997, now 2006. This is Hudson versus Michigan. Here, the High Court held that... High Court. That's another pun because we're talking about drug war primarily, right? The High Court held that evidence seized in violation of knock and announce was not subject to the exclusionary rule. So again, the exclusionary rule, if they violate the principles of the Fourth Amendment, they get evidence outside of the restrictions of the Fourth Amendment, and they try to present that in court, that stuff gets thrown out. So then they say, well, you can do this, there are circumstances where you can go without the knock and announce standard. Now, in 2006, they're saying even if you get evidence outside of those weak standards, you can still present them in court. In other words, Amanda writes, police could still use the evidence in court even though they technically gathered it illegally. So at that point, it's a total green light. So here we are. We start out with this standard, lower it over a couple of decades, lower it, and eventually the floodgates are wide open. And that basically turned these no-knock warrants into a routine tool. Back in the 80s, there were around somewhere between 2,000 and 3,000 per year for the whole country. And about 10 years ago, the last numbers that I saw most recently were about 70,000 per year 10 years ago. I'm assuming they're much higher now, maybe towards 100,000. I would just guess if we're talking about that trajectory, it's to the moon for the police state. And here's an interesting article from Jamila Cummings over at the Daily Bruin, just published yesterday at UCLA. This is a student paper, and I think this is an excellent piece. She writes that the Post, she looks at a study by the Denver Post some years ago, and she said they analyzed a year's worth of no-knock warrants and found that judges only rejected about 3% of them. And from what I've seen around the country, 3% is actually kind of high. A lot of times, again, another pun, a lot of times they reject almost none of these over a whole year period. They basically get an application and they're like rubber stamp, rubber stamp, rubber stamp, rubber stamp. And on top of it, Jamila makes a very interesting find here. Even worse, the Post in their study found that 10% of the standard warrants were changed into no-knock warrants, even if police officers didn't request it. So they're so willing to use these things that even when the cops are not even asking for it, the court is giving them permission to go ahead and do that. So again, this is turning a very important common law standard that the founders based the Fourth Amendment on and various provisions in state constitutions on as well, and turned it into absolute trash. And here's the short version of how things played out. If I can roll up my notes here. First, we've got the federal court making some exceptions to knock and announce that aren't in the Constitution, period. Then they applied the Fourth Amendment to the states. And then instead of taking the original legal meaning of the Fourth Amendment to the states, so a lot of people, good people will cheer this, thinking this is going to be a good result. Now, instead of the states being held to that high standard, or maybe the states individually, like California, were doing a poor job under their own constitution, now everyone is held to a lower standard. Then they took that same watered down standard and basically said, even if you violate that standard, you can still use the evidence in court. And they continued to water it down and down and down. And now we have almost no restriction on this at all. Here's how Amanda sums it up. In her article, she says, without specific restrictions from the state, so if the states don't actually come in and start creating restrictions to protect them from the Supreme Court standard forced or thrust upon all 50 states over a period of decades, police officers generally operate within the parameters set by the Supreme Court, the High Court, once again. So it's not just police officers, but we also see how state magistrates and courts, state and local courts will, instead of, even when they're requested a standard warrant, they authorize sometimes a no-knock warrant. She says by passing bans on no-knock warrants, and we can do this on a state or even a local level. We've seen places like Pittsburgh and elsewhere, Tennessee, which has done a great job, a lot of great activists in Tennessee to restrict no-knock warrants in most situations. By passing bans, she says, on no-knock warrants, states set standards that go beyond the Supreme Court limits and nullify these SCOTUS opinions in practice and effect. Well, I hope you guys found this interesting. I hope it was educational, more important than anything. I hope you learned something. I'm going to look over in the live chat in just a moment, but I do want to mention I do want to mention while you're here and while you're listening that nothing helps us roll up our sleeves every single day than the financial faith and support of our members. And if you support the work that we're doing at the TAC, you can pitch in for as little as $2 a month. We also have annual 5-year and lifetime plans over at 10thamendmentcenter.com/members. It's all spelled out, 10thamendmentcenter.com/members. I'd be extremely grateful for any consideration you can give to joining us today. And of course, whether you're a member already, you're thinking about joining, you're not able to join, doesn't matter. We're going to keep doing this show because we got to get this information out to people on how to protect the Constitution and liberty when the government refuses to do so, which is constantly. You can also help us spread the word by leaving a review on Apple Podcasts or any other podcast platform, smashing the like button, leaving comments, subscribing, getting notifications on the mainstream video platforms. All that stuff will help trigger the algorithm of the platform and help us show the program to more people. Let me take a look over in the live chat. Ed Head said, I've come for the lamb meat tacos. That's funny. Mind Your Liberty says, need some stickers and hats in the TAC store. Absolutely. That's something. We got all kinds of stuff. I've got this task on my list. Add new stuff to the store. So if you got ideas, Mind Your Liberty, of some things that you'd like to see us carry specifically, feel free to email me, team@10thamendmentcenter.com. That's probably something I can start addressing over the summer. We do need to expand some of the products. Andrew Nappy cites Radley Balka, who does a lot of great work on this, who I also cited in one of those, probably both of those other episodes. When it comes to drug searches, there's no longer a knock and announce requirement. There's barely still a Fourth Amendment at all. And that's what happens when you rely on the Supreme Court to force the states to do the right thing. They force the states to do what they want, which is a crappy version and has nothing to do with the founders presented or ratified in the Constitution. Clay Kent, SCOTUS has no constitutional right to make federal law. Well, yeah. Now, lots of comments about tacos. That's always fun. Good to see you, Sheldon Williams. I appreciate you being here. Haji said, so safeguards got watered down to being ineffective? I'm shocked. I tell you, that's Haji 1954. Also, great work by Amanda Bowers. Joe Jelovic says, some kind of restriction must exist, not to be forced upon those who are not consenting. I'm not sure what that means, but there certainly has to be restrictions on government. And restrictions on government, if you rely on government to restrict government, like what people are doing here, you're going to be really, really sorry. And then you're going to be decades and decades behind on trying to resolve the issue. We're starting to see some places with some restrictions on no-knock warrants. Utah has a very limited one that applies just to purely drug war warrants. But Tennessee and Connecticut have much stronger restrictions. I've heard something in Virginia, but I keep seeing legislation from the red team to try to water those down. Joe says that is what I'm saying. Okay, absolutely. I appreciate that message. Hopefully I understand all the other. I try to get this stuff in context, but when I'm scrolling back, sometimes it's a little difficult. Taking a look a little further, Run Level Run has a bunch of comments. I appreciate that. War on drugs. How about a war on tyranny, says Clay Kent. Tom Norman says asset forfeiture is BS as well. And certainly this all kind of ties in. And when you look at organizations that are working on restricting these no-knock warrants, a big part of it, if you're just looking at that, if you're not also addressing the joint task forces with the federal government, the civil asset forfeiture, the warrantless surveillance, and the gun control, they all tie together into one giant nationalized police state that was never intended under the founders and ratifiers' view of the Constitution. Anyways, I appreciate you being here. I hope your week is off to a great start. Again, please don't forget about that membership program, 10thamendmentcenter.com/members, or reviews on Apple Podcasts. It helps out a ton. Thank you so much. Thank you so much for watching. Thank you so much for listening. I'll see you next time here on the Path to Liberty.